Good morning, and to the 14th edition of Bar Talk. Thank you for all joining us that are able to join us today. I want to say thank you to Angela Weston for carrying on the torch when I attempted my broadcast from home with many technical difficulties yesterday. So as far as emergency and executive order updates, there was yesterday PMO SJC 4 that was issued by Acting Chief Judge Meade, and that postpones our bar exam in the state of Maine till September 30th and October 1st. And what's great is we're going to have Chief Meade on shortly. And I made a note too that we had been receiving at least 2 questions from attorneys that are preparing to swear in the state of Maine, asking what processes are going to be set up to allow attorneys that have applied to be attorneys in Maine, barred in Maine, to be sworn in. So maybe we can glean some more from that today too. I also wanted to touch base. People have asked for examples possibly of motions for expeditious hearings. And one of the things I wanted to share is I released one of these motions on Tuesday. And there are a couple things that I just wanted to note. One was that when you do those motions, a response is expected within 3 days from opposing counsel. And generally, I think in those cases, you probably already have started or have an ongoing case. So hopefully you already have opposing counsel. And in those cases too, I believe Rule 5 allows you to serve opposing counsel by email. So with opposing counsel, these emergency motions should be able to be heard quickly, and I'll keep you further updated on how fast that process moves through the court. With that being said, we do have, I believe, Acting Chief Justice Meade with us today, and I did want to thank you for coming on board, and we do have some questions for you if there isn't enough information to share. With that, Chief Meade, are you there? You may, if you are there and we aren't hearing you, maybe you need to unmute.
How about that? Can you hear me?
Yes.
Okay.
Thank you.
Thanks, Ed.
Sure.
And thank everybody for joining us here today. I really appreciate this opportunity to speak to you. We have been in full screech mode on the judicial branch end of things, and our only real mode of communication has been the website. This is a great opportunity to get the word out further. So thank you for that. What I'd like to do is just take you briefly through where we've been, where we are, where we're headed, the decision-making process. If you have not checked in at the JB website, I recommend you do so. It has the reduced hours posted on a weekly basis. And it also has a banner you can click to get access to our PMOs, our pandemic management orders. And as of yesterday, we added some frequently asked questions, some FAQs, which kind of boil down the essence of the PMOs and make them very accessible for anybody to review. So I do recommend that to your reading if you haven't done so already. The historical perspective, I think, is really important because it informs our decision-making process presently and going forward. So let me walk you quickly through that. Late in the evening on March 15th, I returned from an exhausting trip to Guatemala to find an email from the Chief Justice calling a meeting of the entire court leadership group early the next morning. And since then, we have been in daily meetings attempting to address how we will deal with the public and the administration of justice, and also in-house with our own employees, which creates its own level of measures we need to undertake to address that. We understand that one of our prime directives is protection of the public, but unlike a theater or a restaurant, we can't simply shut down because we administer justice. We provide a forum for resolution of conflict. So our challenge was to balance those two overarching principles, and for that we were informed by our long-standing list of scheduling priorities. As you know, the court for a long time has had in place priorities for how cases get scheduled. So we went to that, and we arrived at a scheduling policy to protect the public, protect our people, but nevertheless address those urgent matters, which was focused on two things. One was people getting hurt, people in danger, people who are in danger of being killed or injured, and also constitutional implications, liberty implications for those people who were incarcerated. So that sort of was the come out role for our policy going forward. We issued orders, things got organized, and our current policy is governed by the PMOs issued by the SJC and also by the trial court chiefs. And just going forward as a footnote, you may want to have the trial court chiefs on here because they would be in the best position to address motions for emergency proceedings and so on. So we issued those. We created weekly schedules that were kind of shots in the dark. We meet once a week with the trial court chiefs to promulgate the schedule for the following week. As of next week, on Wednesday, we will promulgate trial schedules actually on a 2-week basis. We've been going week by week. We now have some experience. We know how many cases are coming in. We've held approximately 1,700 actual hearings in court to address the priority cases. So I think we are reaching a point in this process where we're putting our heads up. We have most of the fires addressed. We still have stuff rolling in on a daily basis, but I think we're really at a point to look forward about where we go from here, maybe come up with some innovative approaches to these things. We know that we've received requests informally and indirectly from folks saying, gee, we have a settlement on a civil case, a real estate broker versus a real estate agent. We need some court time to resolve one issue. We need to put something on the record. Can we just get in and do that? Right now, our judicial resources and our limited schedule is being consumed by the priority cases. All of our judicial resources are being directed there. We're looking up to see to what degree we can expand things, to open it up to other case types, other proceedings, and we are aggressively and assertively looking at alternatives there. We are looking at video conferencing. I know many of you, perhaps all of you, obviously who are here today, have video conferencing capability. Why can't we just get in and do that with what we have in place? And the short answer is, again, it's driven by our list of priorities. And we need to look to video conferencing first for those cases. And that has its own set of difficulties, mainly that many of the participants in the priority cases don't have access to hardware or bandwidth or wherewithal to get into those. We're dealing with it. We have some proposals on the horizon. I think within the next probably week or two, you'll see some of those bubbling out there. It's going to be an evolutionary process, but we're going to get there. New Jersey has a wonderful video conferencing infrastructure in place. They were working at it long before this hit, so they're a step ahead of everyone else. But we're going to continue to work on our side. Now, your big picture questions are, when is this going to happen? What's going to happen after May 1st? When will we see increased numbers of case types being heard? When is this all going to be happening? When is this going to be over? And the only answer I can give you at this point is It'll happen when it happens. Our decisions will be driven by the science. It'll be driven by the governor's emergency orders. But we, just as much of you, want to get back to business as usual. We exist for the orderly resolution of conflict. That's our prime mission, and we are champing at the bit. We are very, very frustrated by the restrictions we're operating under. And in practice, I was a litigator, so I understand fully that the engine that drives your practice is currently largely sidelined and not firing on all cylinders. So I understand that, but please rest assured that our days are consumed with meetings, creative approaches, what can we do now? And we are awaiting some of those approaches, hopefully, to be put into place. So I know I've overshot my 4 minutes. This actually is a bare bones summary of what's taking place here. And if there are specific questions, I'd be happy to try and address them. I suspect many of them are probably more appropriately directed to the trial court chief. So I'll take a deep breath and hand back to you, Thad, if you have any questions or particular areas you'd like me to address.
Chief Meade, I do have a couple I want to throw out at you, putting you on the spot. And if there are more that come in through chat, we can handle those if you have the time. I appreciate it. So one of the things that you did yesterday is you issued an order that said bar exam in Maine will be canceled in July and rescheduled for September. Now, something must have driven that decision. Could you just briefly touch on that?
Absolutely. There are a number of factors. Perhaps the overarching one was a practical matter, a practical issue. New York canceled its bar exam. Massachusetts canceled its bar exam. So there are a number of law school graduates, an enormous number of law school graduates are looking to take a bar exam so they can get admitted and start working. And as you know, there's a fair amount of interstate recognition of bar exams. You can enter in the reciprocal admission. So New Hampshire was looking at the same thing too, which is the prospect of droves of recent graduates coming up from the eastern seaboard to New Hampshire and Maine and saying, okay, we've got 6,000 people who have applied to take the bar exam. New Hampshire just pulled the plug on theirs a short time ago, leaving Maine as the bullseye in the target for this enormous group of people coming in. We don't have the infrastructure, the law school and everywhere else that we've looked at for being able to handle these numbers simply doesn't exist. So as a practical matter, we rolled it out. That being said, there are people waiting who actually qualify to be sworn in now. They have qualified for being sworn in, and we must address them. So some of them are out of state, some are based in California and other locations. We are looking into the very likely possibility of being able to do that through remote conferencing. And we have others that are in state and would not present a COVID threat to handle them in the meantime. So we literally, within the last day or so, have asked for a plan to be put together by the chiefs and the administrators to work out a way to get these folks admitted to practice in the meantime. So that's the backstory on that order.
Thank you, Justice Meade. And along with that, are you aware of the ABA resolution that I think came out either on April 7th or 8th that was a resolution to urge all chief justices of the highest courts in their jurisdictions to permit fresh law school graduates entrance to the bar without taking the exam?
Yes, that's known as the diploma privilege. We are quite aware of it. We have received a petition from some rising law graduates from Maine asking that we adopt a diploma privilege. The issue was sidetracked somewhat by the fact that our Chief Justice is becoming the Dean of the law school and obviously has a role in that. So our order of yesterday did not address the issue of diploma privilege because I imagine that will be a conversation that will be followed up with the law school and with the other folks petitioning. There are pros and cons to it. Perhaps you have seen them or have heard of them. We have heard of them. We have not as a group, the SJC, discussed the substance of any request at this point. We will have to come to grips with it at some point. But I think that is a discussion that will happen once the chief assumes her duties at the law school, and there can be an organized conversation that goes on.
Thank you, Chief. We had a couple other hot items too. There seems to be some brewing pressure out there related to renters, to tenants, on the residential side. Attorneys are interested in when courts are going to open up to allow landlords to take control and to allow tenants to move.
Yeah, and there are a couple of parallel things that affect that decision-making process there. FEDs were not on the priority list as enunciated in PMO SJC number 1. So any FEDs that are pending right now are on hold until SJC number 1 is lifted. There is no prohibition on filing cases. Filing cases of any type is wide open. If anybody wants to file an FED, they can go ahead and do that. It will be subject to the stay, of course. In the meantime, the other side issue to that was the issuance of a writ of possession after an FED has gone to judgment is something that happens by the operation of the law. The court has no role in that. It's totally ministerial. But the governor has grabbed onto that and has issued an emergency order, which gives her the authority to override statute to say that writs of possession will not issue. So as you point out, landlords are very much on hold right now. They can't get writs of possession for judgments they already obtained. And for cases that were filed and are filed, they're subject to this priority list for under SJC number 1.
Yep.
Like a bunch of other urgent cases, they need to proceed. As to when that priority list will change, I cannot predict because I don't know at this point. But we are very, very much aware of the fact that many, many commercial interests are in a dire state of purgatory for the short run.
Thank you, Chief. One more question I wanted to throw out there to you, since it looks like people are putting in chat questions. And then we are on a strict schedule for 15 minutes, which we've already gone over by 2. Just some brief thoughts. You alluded to having your trial justices address this, but have you guys discussed in general how you're going to address the backlog that's building up for jury trials?
We have, and there's a backlog building up in everything. And once these stays are lifted, there will be an onslaught of people justifiably demanding justice. We know what happens to justice delayed, and we want to get right on top of that. We're going to have a full court press going on all fronts, including jury matters. We will bring in all of our active retireds. We will put into place all of our resources, but there's a footnote to that, which probably is not obvious. We work under a budget. We're actually a little overspent on our ARJ budget right now. The legislature is in recess, and in July, the legislature will reconvene and talk about many issues involving budgets. The resources are down, the revenues are down, the needs are greater. It's going to be a very, very interesting legislative session. We will do our best to make sure that the judicial branch receives funding that is appropriate. But there always looms the specter that budget shortfalls may affect the degree to which we can put up a full court press. Jury trials are critical. I really want to get those back underway. There are collateral issues, which is when we open the door back up and start summoning jurors back in, we will probably get, as other states have received, requests for excuses saying, I'm scared of this. I'm scared of the virus. I'm still self-quarantining. I'm distancing. I want to be excused from jury service. And there raises the specter of mass requests for being excused from jury service. We have not bitten into that issue yet because we have a waiting list of 1,852 hot topics that we're trying to put out at the same time, but it looms out there. The answer is as soon as we can, as best as we can.
All right. Well, Chief, thank you very much for your insights. I know that I wanted to give a shout out to your Director of Communications, Amy Quinlan, and her staff. They've been doing a great job on getting back to us and giving us information when we can and allowing us to submit questions. Thank you very much for joining us today.
And let me say thank you to Thad and the MSBA. This is a great opportunity. We don't have a direct mode of communication like this. I think it should continue. I think we should get the trial court chiefs in here who can talk more about the day-to-day operation of the trial courts, and they know things that I don't have knowledge of on the ground. So let's continue this. You and I can talk about how to do it and when to do it. And again, thank you to the practitioners for understanding. We are just as unhappy and frustrated as you are. So stay well, be well. We will certainly talk to you again.
Thanks, Chief.
Thad, this is Angela.
I'm here.
I've been getting a few emails. Unfortunately, I have the Zoom version that allows 100 people to join this call. I think I'm finding that if judges are going to join us in the future, that I may need to upgrade my version because there are some people that haven't been able to get on. If you know anybody that hasn't been able to get on, please let them know that this will be posted as soon as we are done with the call today. And we'll put it up on our website so people can see what we talked about.
Thanks, Angela. And thanks for getting us on. I'm sorry we couldn't go through the whole list of stuff.
That's fine. And Marty, if you're still on the call, we are going to have probate judges joining us next week, or at least next week will be Libby Mitchell. So I see your comment here. And Jennifer Krekel, I'm sorry we couldn't add your question on the end, but yes, I believe that even if you could get a writ of possession, you wouldn't be able to serve it if the sheriffs are still not serving. So, yeah.
Well, Jennifer, I do want to share with you on that. The reason why I didn't pop out that quick question is I would see what it is that you actually are bound by related to the emergency order of the governor. I know some cities have done their own regulations in relation to writs of possession. I know that in Cumberland County, sheriffs are still serving. So
it's good to know, Ted, that I know that Oxford and Kennebec have told, I've gotten notices that they're not serving.
Wow, Oxford's not serving?
Well, that's the last I heard, so.
Or is it just writs of possession or not serving at all?
I got a message saying they weren't serving at all. So I'm going to check that out since it appears that other places are serving.
Yeah, Cumberland County's going right at it. Yeah.
Brittany just shared that York County is still serving.
Well, I'll check with Oxford and Kennebec again, but I got two two emails basically stating that they're not serving. But that was probably about 2 weeks ago, but I haven't heard anything that they've resumed it. So I'll check that out and I'll let you guys know.
Appreciate it, because I have a case right now. I was about ready to send to Oxford County for service. So let me know.
Okay, I'll check that out and I'll send an email to Angela and she can maybe distribute.
Sounds great. Thanks.
I also just got a text. Barbara said that we've been told the Civil Service Department isn't allowed to serve.
Right. Because that's what I mean. I know the PFAs and the criminal stuff is going forward. That hasn't been barred. But if you're talking about a writ of possession, you're talking about civil service.
Yeah, we've had we've had service. I guess the last actual civil service I had on a family case in Cumberland County was done the last week in March. So maybe something has changed. So. Well,
I will definitely check to make sure about service because it impacts not just writs of possession. And as I heard the governor has said that writs of possession are going to be issued by executive order. Was that correct?
That's what I think Justice Meade said. They aren't going to
Yeah.
be served on or executed on, right? Yep.
So, yep, it's a little bit of frustration for a lot of landlords.
Right. All right. We do.
And I'll email you back.
Yeah, and we can include those questions and answers in our next segment too. I want to be fair to everyone. And Angela, we've got 15 minutes, and that's it. So, all right.
Thank you.
Thanks. Good talking to you, Jennifer.
Take care.
Okay, well, thanks, Thad. Thanks to everybody for participating. You can see some information we put on the slide there that we didn't really get to today, but it's, I think, pretty self-explanatory. And I did receive confirmation that the Muskie dinner has been postponed. They're looking at October. They're looking at a date, but they know that could be an issue at this time. So anyway, it is officially postponed, and you'll be getting word of that next week officially.
Thanks, Angela.
Thanks,
Hey,
everybody.
Warren, I want to go with you. I want to see.
All right, thanks a lot.